One thing that will get people talking about estate planning is the death or tragic circumstance of a celebrity. The estate planning world is carrying a lot of discussion currently since the passing of O.J. Simpson. He died a couple of days ago due to prostate cancer, and there have been questions in the media because his last will and testament public, and people have been asking things like, what was in his will? What did he have? Where did he put all of his stuff? That will didn't really tell us anything. And it's actually not going to tell us anything because it's a pour-over will. When someone comes into my office and they ask for will documents, I'm not going to draft a pour-over will. I'm going to draft a last will and testament that sets forth instructions for distribution in detail with a catch-all clause at the end of all of my descriptions, or in the legal field, what we call a residuary clause. So what exactly is a pour-over will? A type of will that is attached to another estate planning document called a trust. The pour-over will is the entire catch-all for the trust, so it works in partnership. What do I mean by catch-all? When we draft trust documents for clients, usually it's because the client wants to avoid probate, they have multiple properties in different states, they have a large estate, usually worth more than $100,000, a minor child, etc. Many reasons why a person may want to draft a trust, and different people can benefit from trust planning. But when drafting a trust for a client, the trust needs to be funded with assets, property, certain kinds of accounts, etc. However, when people get trust set up and funded, they still go about their life and perhaps won't keep putting or titling assets into that trust because they may create the trust in 2010 but not think about it until 2020. What ends up happening is that the pour-over will is going to catch everything that you didn't, and it just lets the court know, hey, I forgot about these assets, no need to figure out where they belong, put them in my trust. This is what O.J. Simpson did. We won't know what he had, or we shouldn't know what he had, because trusts are meant to be private and only for the interested parties, and depending on the type of trust, the creditors. Since OJ had a revocable living trust, these assets were still his in a sense, and revocable living trusts don't necessarily offer asset protection like an irrevocable trust. I'll do more talk on irrevocable trusts later, but usually revocable living trusts are still sufficient to meet one's goals. There's been discussion as well asking, can the creditors, or in this case the Goldmans, reach his assets? Well, that depends on what's in the trust and the types of assets or income OJ had. This was a normal person, we probably wouldn't know any of this, but since the whole point, because the whole point of a trust document is for privacy, but since OJ is a public figure, something's bound to come out. There are laws, some state and federal, that protect certain income and assets from debt collectors. This is sometimes known as being a collection proof or judgment proof. Means that although you still owe a debt, your creditor has no legal way to collect that debt or enforce a court judgment against you. The types of income that's protected from garnishment, or things that are legally deducted from your check as a result of a court judgment against you. I'm just going to note I'm in the state of Maryland, so this is going to be for Maryland. Public assistant benefits, things like workers' compensation, supplemental security income, social security benefits, state police pensions, life insurance or annuity proceeds, unemployment insurance benefits, and things like veterans benefits. These are going to be the types of income that creditors can't legally collect a debt from you. Additionally, retirement benefits, most public and private pensions. Also something to note, child support or alimony may be taken from these state police pensions, or unemployment benefits, social security benefits, veteran benefits, because the law isn't going to allow you to not take care of your family, so you're not going to get out of that. Those aren't things that would be collection proof or judgment proof. So will the Goldman family get to OJ's estate? Not sure, but they do have a valid claim and a lien. So depending on how OJ's income and assets were titled, what exactly is in the trust, we may not know. Like I said, he's a public figure, so something may end up coming out, but the things that I mentioned earlier, depending on your state and in some cases federal law, those types of income, technically, you can't, creditors usually can't touch those. I hope you learned something today, and as always, if you have any questions, leave a comment below. Also, if you'd like to get started on your estate plan and preserving your wealth and privacy, contact my office at www.leahbostonlaw.com, and I'm happy to help get you started.